Hello, good morning, everybody. Let's unofficially welcome everybody. Let's wait another 20 seconds. We are waiting for some people to. I can see that some people are still connecting. So 20 minutes, 20 seconds. Sorry, 20 seconds, and we can start officially. Um, okay, fine. Good morning, everyone. Welcome to this webinar from Anna Kapusta and me. My name is Grzegorz Wozniak. We are both representing Wozniak Legal, which is a law firm, boutique law firm in Warsaw. We started this 2026 season last week with a webinar on employment issues. Today's topic is, as you can see, shelf company versus brand new company. What's better? There's very often a choice between investors on as a first step of investment that there has to be vehicle company in a jurisdiction, and the debate is always what's better. So we want to present our views and what is the current situation as regards this issue. Um, it's nice to see so many people connected, by the way. So we are very happy that our webinars are being watched and listened to. I just want to give you some practical information first. You can ask questions during the webinar by clicking question button. No other participants will see the questions, so feel free to ask whatever you want. We'll try to answer your questions at the end of the webinar during Q&A session. We intend to go on for approximately 45 minutes to 1 hour, covering really main area or main very overview of the situation and just this practical tips and practical information how this topic or how this issue could be resolved. If you have questions which you cannot ask during the webinar, you can send us questions later by email or by LinkedIn, or you can simply call us. So we'll be happy to assist. So before we start, let me tell you briefly about our company and about ourselves. My name is Grzegorz Wozniak. I am a Polish lawyer, commercial lawyer. I used to work for Allen and Overy for many years. Then I set up my own company. I specialize in commercial and corporate law. Also, recently we are doing a lot of fraud and asset recovery cases. Anna Kapusta is a Polish advocate. She also specializes in commercial and corporate law. About our company, we are based in Warsaw, established in 2007. We have about 15 fee earners, altogether 20 employees. What could be important for you is that we cooperate closely with professionals all over the country. So if we have litigation, dispute resolution cases, or if we have to set up a company in Szczecin, Gdańsk, Wrocław, or Kraków, we cooperate closely with professionals in these locations. So we are small and located in Warsaw, but if the need arises, we could grow and be much bigger for the specific transaction. Uh, we, as a company, we specialize in business cases. We specialize corporate law, commercial law, fraud, asset recovery, litigation, employment issues. Actually, the whole process of investment. We cover the whole process of investment. So from also greenfield projects. So from the first decision to open a company, then to develop the company, the more complex issues. We're also active in the field of mergers and acquisitions. We act very often for clients when instead of setting up a new business, they decide to set up to buy existing company. Now, moving on to today's topic. So, decision what's better in your particular case, whether to set up a new company or buy existing one. We want to just give you general information and see what is important and what is relevant for your particular case. And also, we want to give you information about the opening of bank account, which used to be straightforward, but it's not any longer. And the case study at the end to show you in practice how these issues could be important. So, starting from the introduction of the company law in Poland. By the way, we decided to show you the recent press releases of about Poland. Poland, I have to tell you, is still considered as one of the most popular countries in Europe for investment. Central location, attractive labor market, and tax incentives for foreign investment. These are just some of the benefits of starting up a business in Poland. And to document this, we want to show you the recent press releases. And the first one is the article from the Telegraph by Tim Wigmore from from 8th of January, uh, which starts: Poland was once a communist third world country, now is overtaking Britain. Probably it's a bit of exaggeration that Poland is overtaking Britain, but definitely we see the phenomenon which is being called reverse brain drain. So people, especially Polish people who emigrated to the UK 10 years ago, are now returning to Poland. This is being called like brain drain, when people from one country are moving to country with better prospects and better organized. Here we have reverse brain drain. So people from the UK are returning to Poland after learning very often their profession and language in the UK. So we have this unique situation where we have uh, very well educated personnel and personnel speaking English who can work remotely from Poland. I recommend you read this article before taking decisions of investing in Poland. This article focuses on many aspects, but it gives also information that Poland's growth is not built on traditional Poland strength, which is farming and manufacturing. In addition to these traditional areas, there is something new, which is fin fin industry. So financial institutions, anything to do with digital IT industries. So we have very strong uh, financial institutions, we have gaming industry, we have IT services, we have production of software. So Poland is becoming a superpower in this area, and the quality of infrastructure, the quality of internet and the process of digitalization, especially during the COVID period, has been such quick and so comprehensive that now Poland is become really a superpower in this field in Europe. So that's the first article. The second article is from China, from this Hong Kong standards. It's the article by Michał Kołodziejski, Polish Consul General of Poland in Hong Kong, and it refers to the situation in Poland is not only the country of inward investment, but also country where you can plan your activity between Europe and Asia. And this is particularly important in the context of the recent route north route from China to Europe, to Scandinavia, going from China across Nordic seas to UK and Scandinavia. And last year, I think November last year, there was a first trip of the ship called Istanbul Bridge, which traveled from China to Europe to Gdańsk, and the route proved to be about 30% shorter than the route through Canal Suez. Uh, so these are two articles which I recommend you read and see how important position geostrategically, how important Poland's position is at the moment. Now, briefly, this introduction to Polish company, just a glance. There has to be always three possibilities for someone who wants to open a company. Is either to buy an existing company, which we call shelf company, or to establish a new company in a traditional way, or recent development is that you can also establish a company remotely via S24 portal, which takes 3 days and is really preferable by investors. The choice was better, was worse, depends really on circumstances and your your plans.
Okay, so generally, why investors often decide to purchase a shelf company? So, as advantage, we can see it's the speed and immediacy. And by acquiring a shelf company, the buyers obtains a legal entity that already exists. It's fully registered in a Polish system. And for example, the company generally is entered into national code register, has its tax identification number, has its REGO number, and usually also has its own corporate bank account. So this is particularly very important for foreign investors for transactions where time is critical. In many cases, the company must formally exist before a contract can be signed, before the transaction can be closed, or, for example, before participating in a public or a private tender. In such situations, waiting several weeks for a new incorporation may just simply not be an option. So, another practical benefit is that shelf companies come with a standard article of association and basic corporate documentation. This significantly reduced the initial administrative burden and allows the investors to focus on just operational matters and rather than formalities at very beginning. Yes, so it's very important. And of course, any further adjustments to the corporate structure can still be made after the acquisition. But generally, investor can already operate through a legally functioning entity. So basically, a shelf company is chosen mainly for its speed and convenience. It also it also allows investors to enter Polish market immediately with a minimal initial formalities, which is very important and valuable when the time is decisive. So I think
Yes, and an important point here for you to take it is this corporate bank account. We will come back to this later during our
yes,
agenda because opening bank account is not easy now. The banks do the KYC procedures, so sometimes it takes 2-3 weeks to open a bank account. So very often it could be really advantage. The whole scheme maybe is not so good, but having a corporate bank account, which is such a problem now, is a good thing. So if you buy existing shelf company, it has already bank account, which is a really very strong point because then and of course you have to replace people when you buy company, you have to put your directors and change signatories, but at least the bank account exists and no one can refuse can reject application for opening bank account. So that's really a practical tip. Yeah.
exactly.
Acquiring a ready shelf company in the past it was really, and I think in most of the business jurisdictions this is really one of the preferable solution to buy existing. That's what they call shelf company. You buy a pre-registered entity, and it's easy, but and simplicity is always comforting because it gives us illusion of control, but simplicity sometimes is not an easy, so is not a good solution. And Polish law is very flexible, but acquisition of shares in a company, it looks easy, but it's not easy because before because you can only become the owner of the company if really legal title has been validly transferred from the seller to the buyer. So if anything happens, the there is a risk that the transaction will not be valid. And then so this first step in your investment process is very important. If you even if you buy from a reputable provider, there is a risk that on transaction that something can go wrong, and there are basically two possibilities here, because you can either buy a company, this shelf company, from the uh, corporate structure from another company, which means that you have to really check whether they have authority to sell it, whether they have legal title, whether the documents are properly signed, because it's a you are buying it from the corporation. And so there are issues, and a second option is that you buy it from a from a natural person, uh, let's say Jan Kowalski, who is registered as the first owner of the company. But then there also could be questions, because if Jan Kowalski is married, if his wife disagree, there could be issues that maybe you just bought 50% of the shares, or maybe you didn't buy it all because wife disagrees with the transaction. So in each case, whether you buy from the company or from corporation, or whether you buy from natural person, there is a necessity to carry out the due diligence process and make sure that everything is right, and it's not as simple as it may look. It's what appears very straightforward, if you look at it from the perspective of the UK, America, or any developed economy, because normally buying a shelf company is easy. You just sign documents, you buy company, and it's absolutely valid, cannot be challenged. In Poland, this is exception from this general rule. This is not absolutely valid. If you we have this Latin maxim where you cannot transfer more rights than you have. So if the seller, for any reason, has no rights, or has not been properly represented, the seller is not transferring rights to the shares to you. So you may start the process, build a factory, or be a participant in an important tender and win the tender, but then it can turn out that you actually don't have the shares in the company. You don't control the company. So uh, every choice has consequences. So it's and the truth is that nothing in life is ever so simple. So that's why also we decided to have this webinar, because the uh, this topic, brand new company versus ready-made, seems very obvious. That there are no nuances to this. It is, there are many nuances. I warn you to use ChatGPT on this, because it normally, I was checking this before our webinar, it normally gives you wrong answers uh, on the acquisition of shares, and when is the crucial moment for acquisition of shares. This is all very delicate issues, and the most important factor also is that registration. When you buy a company, and when they show you extract from the register, which in normally in the UK, in America, and in most countries, it is a proof that you are already the owner of the shares. Registration in the commercial register, or registration entry into the register of Jan Kowalski, doesn't really mean that he is really the owner. It has to be, you have to verify this looking into the share agreement and see whether the transaction was validly done. If not, nothing can save you, and you are not buying the shares. So that's why this is still an option, acquiring a ready-made company. Sometimes, depending on the situation, maybe this is really, especially if it's a solid and reliable business provider, you can buy. Although I was also checking this, KPMG and big accounting firm, they stopped selling ready-made companies because there are too many complications. So you can buy shares only from local Polish providers, and there are many risks associated with this. And of course, later on, after acquisition, you have to appoint new directors, amend the articles, as Anya mentioned, and go through the whole process. Good thing is that you have. I want to reiterate this. You have this. The company has the bank account, and this is important because you cannot operate without bank account. This is it sounds like cliche, but it's also very important. Company needs to have a bank account. So that's about acquiring a ready-made company. It is easy, but believe me, this is not a straightforward process.
Okay, so what we need to say is this is acquiring a shell company. It's only the first step. So in practice, buyers almost always need to make a number of post-acquisition adjustments to tailor the company to their actual business plans. So, shelf companies typically have very generic features. So, this includes a standard company name, template-based scope of activity reflected in the PKD codes, which generally often do not correspond to the buyer's intended operations. So, you need to change it then. As a result, these elements usually need to be, as I mentioned, changed, updated shortly after acquisition. So common post-acquisition steps include amending articles, also association, for example, changing the register office, appointing or replacing members of the management board, and change the share capital also. These changes allows the buyer to fully align to the company's corporate structure with its commercial and operational needs, of course. And it is also very important to know that shelf companies are usually not registered for social security purposes or EU VAT. If the company plans to employ staff or engage in cross-border or VAT-relevant transactions, the appropriate registrations must be completed separately after the acquisition. So it's very important. Also, from a procedural perspective, many of these adjustments require a formal amendments to the Articles of Association, followed by filings the National Code Register. While some changes are relatively straightforward, the registration process itself may just take up to for 4 weeks, which should be factored into the overall project timeline. So to summarize, generally acquiring a shell company, it's only a starting point, and most buyers need to implement post-acquisition changes to fully adapt the company to their business, and also these formal adjustments require time and careful planning for everything. So they are also very important. Now let me tell you more about our second option. So incorporating a new company via S24 system. So in recent years, the advantages of purchasing a shelf company have become less pronounced, mainly due to the development of S24 online incorporation system in Poland. And today, a limited liability company can be established entirely online through the S24 portal, often within 1 to 3 business days. So this process is very efficient. The company is registered directly with the National Court Register, has the KRS number, NIP number, REGO number, and those numbers are assigned just automatically. And as a result, investors can start operating quickly without the concerns that sometimes arise when acquiring an already existing entity. So the S24 procedure does have some practical limitations, especially for foreign investors. So first of all, is platform. Because including all of forms and instructions is available only in Polish. So for this reason, foreign funders usually require assistance from Polish lawyers or some local advisors just to navigate the process correctly. And also, what is very important for foreign shareholders must meet a certain technical requirements. Because to use S24 system, they need, for example, a vessel number combined with an EPUB, so our trusted profile or qualified electronic signature that is recognized in Poland. Also, another
And
yeah,
just to jump in, so but we are helping clients,
yes,
so because of this limitation that is only Polish version, but we are helping clients with setting up the qualified electronic signature,
yes,
and then the whole process can be really simplified and streamlined so that they can authorize. That we need to set up the qualified electronic signature. They can authorize us, and we then go on with the process. That's very useful.
So another important limitation is the lack of flexibility and incorporation stage. The article of association must be based on a standard statutory template with no possibility of customization at that point. However, it is not permanent restriction. We can change it later once the company has been registered, but we have to go to the notary to do this. Despite the constraints, the S24 system still remains a very attractive option, particularly when speed and simplicity are the main priorities. So to summarize it, S24 is a very fast and efficient online incorporation system. Uh, it's making an excellent alternative to a shell companies when time is critical, even though it comes with some formal and technical limitations. So just for foreign investors needs to think if there is a it is a good option for them. Here.
Yes. Is buying a shelf company a good option? I mentioned that there is this problem when you buy existing company. It's important to do it in accordance or through the valid share purchase agreement, which requires due diligence as to the legal title to the shares. The second, and we say here, primary drawback lies because it can be the verification of the legal title could be done. It should not be an issue because it's basically this ready-made companies. They wait on the shelf not so long. It could be half a year, and then there was no operation. So, and there normally is just one buyer or one owner. So when you buy existing company, you buy from this one from the seller. But the main problem, which there is no solution to, is that, and this is this primary drawback, is that there could be some undisclosed liabilities in the company. There could be some just bill of exchange, could be some papers in the drawer, and you buy the company because you buy the company or you buy shares, or you buy the company as it is. So there could be undocumented loans, could be promissory note, could be bill of exchange, could be anything in it. It could be some penalties, and of course the agreement. Standard agreement contains reps and warranties and a clause on no prior activity, but if there is a claim against the company for unpaid penalties or unpaid loan, the company has to pay. So you may, if you build your investment on the newly purchased company and you are not fully aware what's inside, then there could be issues. The second problem is that very often investors or the government or the institution organizing tender requires that there's clean record. So they want to know who was the previous owner of the shares, or who controlled the company before you. So the issue of cleanliness would be an issue. That's why um, to do it properly, you would have to uh, look how many problems it may generate, because you have to check the legal title just to be sure that everything's fine and you really purchase. As I said, you cannot move under Polish law. You cannot transfer more rights than you have. So you have to check the legal title. You have to check undisclosed liabilities, and you have to check corporate history and accounts. So basically, if you want to do if you want to act quickly, you either do it with closed eyes and without doing due diligence, or you have to go through the process of due diligence and checking legal title, uh, documents of the company, and making sure that the company has really no breaches, and then you can buy. So on the whole, this is making this option, buying the shelf company, less and less uh, preferable for investors. So if clients ask us whether there is any risk and how to mitigate this risk, we say that there is a risk which cannot be mitigated, because it could be even $1 million loan in the company, which needs to be paid after you build already your structure on this. So this first step in your investment process is very important, and I know simplicity is welcome, and we all are looking for simplicity, because simplicity gives us the illusion of control and we want to understand things, but actually we live in the world of complexity, and you need to involve lawyers to help you in this. Uh, so the question is, buying a soft company a good option? Probably, I would say no. Probably you would rather check other options, which is as Anna said, this portal, which gives you phenomenal possibility of opening company within 1 2 business days, or traditional model. You go to the notary and then just prepare documents. So it takes 4 weeks, but you have a company with absolutely no risk and no history. So you have clean track record. You have no liabilities. Um, so it's not a good option, I would say.
Opening the bank account in Poland. So finally, I will tell you more about the issue of opening a bank account in Poland, which is often,
Just before you start, maybe,
yeah,
so opening bank account applies to both options, traditional
yes,
model and S24. Yes, so the only model where you have already bank account is this buying a shell company, but this applies to both registration of the brand new company. Sorry.
yes. That's also often one of the more time-consuming critical steps for new companies. So for Polish limited liability company, opening a bank account is generally only possible once the company has been successfully registered in the National Court Register. And after registration, the company must gather a set of corporate documents and submit them to the selected bank, usually during to the visit in a bank branch. Um, so Polish bank applies strict know your customer and anti-money laundering procedures. As a part of this process, bank carefully verifies the company's structure to identify of the shareholders and also the directors, source of funds. For companies with foreign shareholders, the due diligence is often more extensive and can take anywhere from 1 to 4 weeks. In practice, banks also require the personal presence of at least one management board to sign the necessary documentation. This is important practical point for foreign investors to consider when planning timelines and also logistics. As a result, while company registration itself may be relatively fast, opening a bank account should be planned in advance, as it become a bottleneck in starting full business operations. So generally, to sum up, opening a Polish corporate bank account requires priority company registration throughout KYC and AML checks, and also personal involvement of management, which means it often takes longer than just incorporation process itself.
Yes, and it is very difficult for us lawyers to speed up the process
Yes.
because if you happen, and we have such cases from my experience, so if you it depends how complicated structure on the side of investors are, because if we have cases from the Netherlands, which is started to be very popular to have family funds, family foundations involved in the as a shareholders in the whole structure up to the ultimate beneficial owner. So if you happen to have family offices or something which is not so transparent, or there were family funds, uh, all these information has to be verified by the bank during the process of opening bank account. And there's very little we as lawyers, of course, we can try to explain it to bank managers and provide legal opinions and provide additional information, but still it goes to the legal department of a bank's legal department. They analyze it. So actually this is something also very important, because maybe in the process of choosing which company would be the parent company for the Polish investment vehicle, it if it's too complex on your side, then you may it could be that that you will be waiting for the decision on opening bank account 2, 3, 4 weeks, because they need to report. They have so many obligations. Banks have so many reporting obligations, so many requirements to check the status of the client, that it takes time. So it's also something really important, as Anya said, that before even starting the process of setting up company, to choose the bank and to find and to organize. We have to think 3, 4 steps ahead. Yes, and plan carefully, and taking into account that opening bank account in Poland is not such a straightforward issue. In this sense, they're buying the existing company could be, but this is not decisive, I think, because sooner. And maybe also important tip, practical tip, is that there are at least 50 commercial banks in Poland, or banks and financial institutions. So you can choose from them, and they have different requirements. So there are banks which are very strict, and it's very difficult to work with them. So sometimes we just try with several banks, and then we try and we look for the best option or the best offer. I don't want to mention any names now, but it's a question of if we have an investor from Germany or France or UK or America, it differs. So it will be but it's a process which needs to be planned definitely. So uh, please take it into consideration. We didn't talk about traditional way of registering company, which probably is not so important now, because if we compare these two models, the most important comparison is between, because they are short and quick and immediate. As I said, it's the advantage lies in this immediacy. Yeah, so you can immediately have the company within 2, 3 days. So that's why we wanted to show you the immediate action when you buy the company, because then you buy and you sign the contract, and you are the owner. And or the other solution is you register the new company through the remotely, and you also have the new company within 2 3 days. So these two, and we think there are really a lot of advantages of starting a new company. While the traditional model is really the slowest and the most painful and the most costly, because you need to prepare the you need to prepare the articles of association, you need to collect the documents, which is very important because you need to go back to your jurisdiction. You have to prepare the notarial deed and notarial power of attorney in a notarial form, and this has to be notarized. Or it has to be apostilled in your country. Then it has to be sent to Poland. It has to be translated. Then we have to go to the notary, sign the articles of associations, file the application for the registration. It all can take. Registration itself may be 2 3 4 weeks, but the whole process with drawing up power of attorney, obtaining apostille, it can take weeks and weeks. So altogether, very often it takes about 2 months from the first day until the registration, and then there is a application to the bank. So look how long this process could be if it's not properly planned. So instead of going through all this painful process, it's very good to use the latest technology and use the remote system S24 with our consultants' help, and shorten this period as much as possible. So the case study which we prepared is based on such an example, vivid example taken from our experience as well. It's a it talks about the American corporation based in Phoenix, Arizona, and they want to taking advantage of the reverse brain drain. So a lot of Polish people returning with high qualification, returning from, actually they're not returning from America, but they are returning from the UK to Poland. People who left for America never, or very rarely return to Poland, but plenty of people return from the UK. So the US corporation wants to create a company and employ ITs, programmers, Polish programmers in Poland, working on US software or software for US clients, and they want to participate in the nuclear power, in the construction of the nuclear power plant, which has to be designed and has to be a lot of the will be one of the biggest project in this part of Europe, construction of the nuclear power plant. And then there will be a lot of designing and IT work. ABC Incorporation wants to set up a company. They need a company, and they want to take part in the tender. And they decided to buy a shelf company, which is a traditional way of doing things in America, and in most advanced economies, you go and buy existing company, and then you try to remodel it for your purposes. But they come up with a wall, and it turned out that hey, they need a power of attorney, which is, as I mentioned, as a draft, as a notarial deed, and it's not so easy with notaries in America because you have common law countries, civil law countries. The concept of notary is different. In Europe, those who listen us from Europe knows that we have a Latin concept of notary, which actually is involved in many legal transactions. So any real estate transactions, any setting up companies, foundations, divorce, even in inheritance documents can be signed in front of the notary. In the UK, in common law countries, there's no such a system. So ABC in this case study found out that it's not possible to, it's not so easy to prepare a notarial deed, and then this notarial power of attorney has to be apostilled, which is the special clause which confirms that this document has been drafted, has been drawn up in accordance with the laws of Arizona, and this all takes time, and then has to be sent in original to Poland for translation. Uh, and as an additional argument or additional requirement from the organizer of the tender is that from the Polish government, very often there is a cleanliness of the company. So they want to make sure who was involved or who was the owner of the shares before, just to make sure that there are no threats. Yes. So they come up with a problem. How to do it better? They are looking for other solutions because the process is too complicated. And actually, what we suggested to them, that we can take advantage of the latest technology, of the fact that Poland is so so developed in this process of digitalization, that we can actually make the whole plan that we will register the company remotely, uh, by by setting up the qualified electronic signatures. So we know that the system will be, or the new company will be very simple. So as Anya mentioned, there is no possibility to modify in any sense. So this is a very simplistic, very primitive option, variant of articles of association, but we can deal with this later. So we agreed the plan with the client that, okay, we first step would be to establish, to set up electronically qualified signatures for them. Then they give us powers of attorney thanks to these electronic signatures, and then we can continue with the process, helping them to sign the cookie, because the process is just click and uh, click and drag, yes. And then the company was registered within 2 days, ensuring full control of the company because they are registered as the owner, ABC Incorporation, with a clean history as the first shareholder, which make it ideal for this clean record requirement under Polish procurement law. And additional advantage was that there's no hidden liabilities or undisclosed liabilities, because we know that it's a brand new company. Uh, Is this process so easy? Of course not. Maybe Anya will develop this, how they should give power of attorney.
Yes. They should give us a power of attorney and sign it with an electronic signature, and they are authorizing us to have an access to this system, and then we file the motion online and access everything online, and then after 2 3 business days we have a company. So it's very
We also need to appoint directors straight in this application for the registration. For the whole process is completed quickly within the 3 days, and we have and all the numbers, the numbers which we mentioned. So registration, regular number and NIP number. So it's definitely a solution which should be recommended. Um, and in this case study, you see vividly how important it could be if time is of the essence, whether to, because it, maybe 10 years ago, the acquisition of the existing company, of shelf company, was solution based on the UK, on the American system, because it was a copy from this system. But the Polish law is very flexible for investors. But as you can see from this example, even Polish law, although very friendly to investors and very flexible, is based on very strict legal regulations, and you cannot breach them because it could be catastrophic. Uh, and actually, as I can just to end this webinar, I can say that we live in the world of complexity. Simplicity would be required, but it's not possible. You have to. Uh, you have to be wise, and you have to wise choosily. Every choice carries unseen motives or unseen consequences, so you have to plan in advance, and you have to ask proper questions and get clear knowledge. Uh, uh, and I know that everybody is looking for simple answers, but believe us, there are no simple answers in this world of business investment. You have to hire proper lawyers. You have to make the plan careful and you have to stick to your plan. Otherwise, there will be problems. So that's all from us. No, sorry. Yes, yes, we have questions. Yes, I mentioned we have questions. We have many questions. So we are happy to answer the. Maybe we are running out of time, but maybe we will be able to answer some of these questions. Yes. Hello. Um,
Here we have some questions.
what the when the changes to the management board become effective after acquisition of the company, uh, upon resolution of shareholders or upon registration in the commercial register? So actually, it's a very good question. That it refers to my complexity word. Where it's not simple. We are looking for simplicity, but it's a complexity rather. It's so the changes become effective at the moment upon resolution. So if you buy existing company and want to put your people on the board, so let's buy today we buy the shelf company and we today we take the shareholders resolution to amend to change the management board because we want to put our people who go to the bank and change and be new signatories. So the change is effective upon resolution, but you are not registered in the registered yet. So to the to third parties, you will not be visible. So the first problem would be that the bank will look at the extract from the commercial register and say, no, no. So okay, I understand that you are now the new CEO, but you are not registered here. So so the answer, as you can see, is that yes, the changes to the management board are effective, become effective upon resolution of shareholders. This is absolutely true, but there is a big risk that no one will honor this because they will be waiting for the proper registration for the document from the commercial register showing your name. So you can be in suspension. Next question.
Next question, maybe this. How do Polish banks typically view shelf companies compared to the newly incorporated entities during the KYC process? So, generally, in practice, banks focus less on whether the company is a really a shelf company or newly incorporated company, and they are more checking the ownership structure, management, source of funds. However, basically, the shelf companies are sometimes checked more closely, just to confirm if they had, for example, some prior activity. And this is why, clean documentation and also transparency, it's crucial, and regardless of the incorporation methods. So the answer is, banks analyze more ownership structure and management rather whether the company is a shelf company or a newly incorporated company. So it really doesn't matter.
Okay. The next question we have: how can I verify who is the shareholder in a SPZU company? Isn't sufficient to rely on the entry in the commercial register. No, this is not sufficient. This is the presumption that whoever is entered into the KRS, we call it commercial register KRS, it could be true, but it does not have to be. So this is, I mentioned this during our webinar. This is one of the features of Polish company law that actually uh, you cannot really follow or build your plan on what's in the register because it may not be true. The only way to make sure who is the shareholder is to verify the transaction. So uh, when you buy shelf company, there's only one buyer, so it's relatively easy. But if I can tackle this question in a more in a wider context is that when you buy shares in a company and there have been there were several transfers, you need to really check every transaction, because only uninterrupted chain of valid transfers makes a valid transfer of shares from A, B, C, D. So unfortunately, this is different than any other jurisdiction in Europe we're working with, because if you look at the UK, you normally you check company house, and whoever is registered as the owner, you can buy from that person. This is not the case in Poland. So this is very tricky. And I warn you, because even if you try to find for answers and you ask ChatGPT or Perplexity, very often I keep receiving questions from my clients because they send me answer for Perplexity where the solution is different. To, as I said, they normally refer to entry to the KRS is a final proof of the ownership or share register. Because very often companies have share registers which are kept by the company. So sometimes you may find answers from ChatGPT that maybe that share register is the final proof of the ownership. No, this is not true. Share registers very often are not used and any longer. There is a formal obligation to keep share register in the company, but many companies don't keep it, especially in the digital area where they keep it maybe just in Excel. They keep information who is the owner. They know who is the owner, so they keep it for themselves.
I don't know if we have a time for more. Maybe I can answer
Yeah.
on this one. So, how limiting are the standard articles of association used in the S24 system in practice? So, in general, the standard articles of association which are used in the S24 are very simple for simple projects, simple companies, which contains 1, 2 person. It's enough and it's very efficient. But if you want some more complex arrangement, the structure is more complex. You need add some extra protection, some preference rights. You need to change this article association.
So I think it's ideal really for when you have just a subsidiary, so
Yes.
100%, so just one shareholder,
Yes.
because then you don't care really. There are no balance of power, just one company. So
Yeah. So it's simple. It's enough to run a business, but only in a simple case.
not very
simple
sophisticated,
persons,
yes.
yes.
Not very sophisticated.
But for more complex businesses, you need to generally amend, make.
Yeah, so the plan, even from our case study, was that we go with the first step. We register the company as a very simple structure, and then only upon amending the articles and making all the changes, we adopt the proper structure, which would be good for the business. So two steps. Which carries us to another question, because the question is buying a shelf company actually more cost effective than here we have the company. The question is buying a shelf company actually more cost effective than incorporating a company. Yes, it's very difficult really to compare, because as you can see, there's always, if you plan carefully, it has to be two stages of the whole process. So if we and we normally act for companies which set up subsidiaries, so 100% just one shareholder. So the process normally is two stages or two steps. Step one, opening, so setting up such a simple company with no sophistication at all, and then going to the notary and changing it, adopting the proper articles of association. So it's two stages, and so you have to look at in totality on this, and then and then buying existing company. It's in this sense is quite similar because you, in the first step, you buy shares in an existing company, and then again you go to the notary and change the articles, change the governing bodies. So two steps. I would say my guess would be that the cost would be comparable because you have here the first step, setting up a simple company remotely would be cheaper probably, but then you have to still do the whole process once again. Ac- Acquiring the company would be probably two steps. So on the whole, I think it's really comparable.
Okay.
Okay, I think we run out of time. We promised 45 minutes to 1 hour. It's 1 hour. So thank you very much for your attendance. We uh, we want to see you again during our webinars. As I said, we started last week with the webinar employment. Today is a brand new company versus shelf company. These questions are very good for the feedback from us is very good for us because we see what could be of interest. So we are planning next series of limited liability or webinars about shares in the limited liabilities companies and investing in Poland. That's all from us. Thank you very much. Bye bye.
Thank you very much. Bye bye.